Hello and welcome back. This video is going to be on intoxication. So we're going to have a look through at this defence and how you would be able to answer this in the exam. So the very first thing to determine when you're looking at intoxication is the difference between voluntary and involuntary intoxication. Voluntary intoxication is where someone voluntarily or chooses to take alcohol, drugs, glue, so sniffing glue, or prescription drugs with a known intoxicating effect, so you know that it's going to make you intoxicated. Compare that to involuntary intoxication. That's where you might have been spiked or drugged, or perhaps where you have an adverse reaction to a prescription drug. We'll look at a case later called Hardy, which fits in really nicely with that last point. The second thing you have to be aware of is the difference between specific and basic intent offences. Now, criminal offences can be divided into one of the two categories, essentially. This is quite a complicated concept, and it's one of the things that people usually struggle with intoxication. Specific intent, the offences you can see in that column, are all offences where you have to prove that the defendant intended to do something. So for instance, if we look at murder, you have to prove that the defendant intended to kill or do GBH. You cannot convict that person unless you can prove that intention. In Section 18 GBH, under the Offences Against the Person Act, you have to prove that they intended to do serious harm. If you can't prove that, they're not guilty. Equally in theft, you have to prove that they intended to permanently deprive the owner of the property. If you can't prove that, you cannot find them guilty. And similar with robbery, we have to prove they intended to do the theft, etc., and things like that. Basic intent, on the other hand, is where you don't have to actually specifically prove an intention. You might be able to, so I'll talk about that in assault, for instance, of battery and ABH. But actually, the offence can probably be done either recklessly or another form of mens rea like negligence or something like that. So actually, you do not have to prove that the defendant intended something to be able to convict them of it. So for instance, under manslaughter, you have a range of manslaughters that you look at on the course, from gross negligence manslaughter, but reckless manslaughter would be a good example where you do not have to prove that the person intended to kill or do GBH. Simply, if they were reckless, that is sufficient. Under Section 20 GBH, the mens rea is intention to do some harm or recklessness as to whether any harm is caused. So actually, you do not have to prove intention. You can just, if you can prove the recklessness part, they're guilty still. Similar with assault and battery, it's intention or recklessness is the mens rea. So assault, intentionally or recklessly causing the victim to apprehend the infliction of immediate unlawful force. With battery, it's intentionally or recklessly applying unlawful force. In both of those offences, you do not have to prove intention. Recklessness is enough. So if you can prove the defendant was reckless, they can still be convicted of the offence, and similar with ABH. Now that's the difference between the two different types of columns there. So you've got on specific intent, you have to prove a specific intention. I don't know if that's why it's named that, but it makes sense. But it's specific intention. To find the defendant guilty, you have to prove specific intent. With basic intent, it's the basic intent name you can kind of ignore, because actually what it means is it can be done through recklessness or something else. So actually you do not have to prove an intention. That might not be the specific legal definition and things like that, but it's the easiest way to sort of understand the difference between the two. Now you have to understand that, because if you don't understand that, intoxication, the topic, can be really difficult. So once you know those two things, so just flicking back to voluntary and involuntary and then specific and basic, you can then start to work through the topic and understand, well, when can you use this defence? Now, you've got a little table here which basically tells you the answers. So basically what you do is you put voluntary intoxication and involuntary intoxication along the top and specific and basic down the side. And you can see there that you can use it potentially for specific voluntary, for specific involuntary, but not for basic voluntary, but you can for basic involuntary. Now there are tests, that's not a one size fits all, that's not the answer. You then have to look at, well, when can they use it for specific voluntary, for instance, which is what we're going to look at next. But it gives you a general sort of framework to work around as to when potentially you can use it. So if we look at voluntary specific first, so it's the top left corner there where it says yes. So if you go down with your finger from voluntary and then cross from specific, we're going to look at that box. So if the defendant is voluntarily intoxicated and is being charged with a specific intent offence, so that might be murder, Section 18, anything from that list. So for instance, I'll give you an example. Mary drinks a bottle of vodka, then stabs Robert to death. She says she can't remember anything and she's being charged with murder. So we know it's voluntary intoxication because she chooses to drink a bottle of vodka. And we know that murder is a specific intent offence. So that's your first two things you need to establish. So the main rule for then deciding whether someone can use intoxication in this circumstance is to ask, was the defendant so intoxicated that they did not form the mens rea? So they've got to basically be able to prove that they were so intoxicated they never formed that intention to do, if it's murder for instance, to kill or do GBH. So they have to, so in the second, if you look at the second bullet point there, in this case, the mens rea for murder is intention to kill or do GBH. So Mary was so intoxicated, she didn't form this mens rea, and she'll be able to, the fact that she couldn't remember anything and things like that, she might try and use to say, well, I never did form the intention because I was just so intoxicated and so drunk in that instance. If the answer is yes, then they can use intoxication as a defence to not be guilty of murder, although bear in mind in the next few slides, there is a next stage as to what happens next. You're not fully acquitted from murder, for instance. There's a next step, which we'll look at in a minute. So we know this from the case of Beard, which was a fairly unpleasant case. He killed a woman during a sexual offence. Now, before the case of Beard, the law had always been very clear that intoxication was an aggravating factor rather than a defence or excuse. It was seen as worse. If you killed someone or did an offence whilst drunk or on drugs, the court actually treated you more harshly. It was certainly not a defence. But Beard put a sort of line in the sand here and said, well, actually, on legal principle, if the defendant does not form the mens rea because they were so intoxicated, they can't be guilty of a specific intent offence. They cannot be guilty of an offence if they didn't form the mens rea, because the standard legal rule is that you must form the actus reus and you must form the mens rea to be guilty of an offence. Now, there are a couple of other cases that demonstrate that. Shearer and Moore, again, a fairly unpleasant case where two defendants set fire to a homeless man and burnt him alive, and they were able to prove that they didn't form the mens rea because they were so intoxicated. So they were able to use the defence in theory for murder. But again, bear in mind that wasn't the end of the story. And similar with Lippman, him and his girlfriend took LSD voluntarily, and he killed his girlfriend during that. There is an extra case you need to know here called DPP for Northern Ireland v Gallagher, and in this case he decided to kill his wife. He wanted to kill his wife, so he formed the mens rea there. He then got drunk to kind of build the courage, and they call this like Dutch courage or silver courage sometimes, to kill her. Now the court had to consider in this instance whether he could use the defence, because strictly speaking, during the actual killing, he's saying, well, I didn't form the mens rea. The answer is very clearly no, as he did in fact form the mens rea. Now, whilst that was beforehand, as you can see down at the bottom, and it wasn't actually during the offence, which is the normal rule, we'll talk about that a bit later, the court was satisfied that he did form the mens rea. And if you think that from a logical perspective, they're not going to let him get away with that because, he still intended to kill her essentially. He just got drunk to do it. So that you have to watch out for that as to when actually they form the mens rea. If it's beforehand and then they get drunk or take drugs, whatever it is, get intoxicated, you would apply Gallagher here and think, well, actually, no, they can't use the defence. So what happens now? We've said that, well, they can use this as a defence for like murder and Section 18 and theft and things like that. So what happens? Well, no, they're not going to be acquitted because that would be ridiculous. And you think someone can't just say, well, I'm not guilty of murder because I was so drunk and so intoxicated. So if there is a basic intent offence equivalent, which they call a fallback offence, then the courts will consider this offence instead. So now there are only a number of fallback offences for certain offences. So you can see two of the main ones there. Murder falls back to manslaughter, and you can see why, because they're basically essentially the same thing. You've killed somebody. And what the difference is really on mens rea or the sort of context in which it's happened. Section 18 equally falls back to Section 20, which is the two different types of GBH. Now, some offences don't have fallback offences. So theft, for instance, there is no fallback. There is no basic intent equivalent. There's nothing else they could charge you with. And we'll talk about the outcome of that then. So what if you can use intoxication for theft? What happens then later? But for these two, and you've got to bear this in mind, if there is a basic intent offence, and the only ones you really need to know here, probably, and I say probably, is murder to manslaughter in set 18 to 20, because they are the sort of main ones there, specifically the ones we do on the course. Now, For these offences, the prosecution does not need to prove that D intended to commit the offences, because we know they're basic intent offences. Remember, that's specific intent offences. You do not have to prove intention. We know that recklessness is normally sufficient instead. So for section 20, you can prove they were reckless. For manslaughter, you can prove they were reckless and still convict them. And we know that the definition of recklessness from the case of Cunningham, which is where they pulled the gas meter off the wall, that it is, did D know the risk and decide to take it? Now, in court, your defence counsel, if you were in the situation, is now going to try and argue that you were so intoxicated you couldn't have possibly known the risk. You were so intoxicated you didn't form an intention in the first instance, which we were just talking about. And in this instance, you were so intoxicated you couldn't even have known there was a risk and decided to take it because you were so intoxicated. Now, if that was accepted in court, that would mean that you were able to use intoxication as a defence here, which would mean you were actually fully acquitted. So you would use it as a defence for murder. They would try and convict you of manslaughter instead, and then you would be able to use it as a defence here as well. Now, that would mean essentially that it would be a full defence where you chose to drink and you chose to take drugs, which seems a bit unlikely. And of course, for public policy reasons, the courts decided that they couldn't let that happen. So along came the case of DPP v. Medusa, establishing the Medusa Principle rule. And what this says, it's a bit complicated, but what it says is that D was reckless when they voluntarily became intoxicated. And what they then do is they supplement that recklessness that you're doing there for the mens rea that's required for the offence. So they're saying, well, it doesn't matter that you didn't form the recklessness for the actual offence when you did it. We're going to say you were reckless anyway, because you were reckless when you got drunk in the first place. So what this means is voluntary intoxication is not a defence to a basic intent crime. You did the actus reus, and the mens rea is essentially ticked off when you decided to get intoxicated in the first place. There are a number of problems with this, which we'll explore a bit later, but that is the sort of basic principle there. Now, the same rule of Medusa applies to a situation where someone is charged with a basic intent offence in the first place. So if there's not a situation where someone's charged with murder and then it's falling back to manslaughter or section 18 to 20, if they're just charged with section 20 in the first place, or manslaughter in the first place, or assault in the first place, or battery, any of the ones in the basic intent list, we know for assault, for instance, the mens rea is intentionally or recklessly causing the victim to apprehend the infliction of immediate unlawful force. In this case, the court says, well, you did the actus reus essentially, and yes, we can't prove that you intended to do it because you were so intoxicated, but the reckless bit, we're saying, well, you were reckless when you voluntarily got intoxicated, so tough luck essentially, and the court will not allow the defence of intoxication. Even if the defendant's saying, well, I was completely intoxicated, even then, they were reckless when they got voluntarily intoxicated. Now you can sort of see that here. So they were reckless right at the beginning there, at the beginning of the evening when they decided to drink or take drugs, and at the end of the evening when they actually do the crime. Now usually we expect you to be forming the mens rea for recklessness at the time you do the crime, but the court here says, the Medusa case says, well, we're satisfied that you were reckless there, and we'll talk about problems with that again in a minute. So what about involuntary intoxication then? So we're going to go right back to the top of the box then. So if you remember that box from the beginning, so if you look at the columns, the involuntary intoxication column, and then the top row, which is specific intent. Well, we've seen in the case of Kingston, the same rule applies here. So the question is, was D so intoxicated they didn't form the mens rea again? So what you've got to bear in mind is being spiked or drugged doesn't give you free rein to commit offences. You still have to prove that you were so intoxicated that you didn't form the mens rea. So for specific intent offences again, that means you didn't form the intention to do whatever it is. Now, two scenarios here that show that. In the first one, Sheila's soft drink is spiked with a strong drug. She's still lucid, so she knows what's going on, and decides to use the opportunity to stab her rival Mark to death. In the second scenario, Sheila's soft drink is spiked with a strong drug. She stabs Mark to death. She awakes in the hospital and remembers absolutely nothing. Now, in the first one there, she clearly wasn't so intoxicated that she didn't know what was going on. So even though she was spiked, she wouldn't be able to use the defence because she did form the mens rea still, because she was lucid or aware enough to do it. In the second one, though, she was clearly so intoxicated, because she says she doesn't remember anything, that she actually would be able to use the defence here. So you've just got to be clear that being spiked and drugged doesn't automatically mean you can use the defence. You have to still prove you were so intoxicated by that spiking or being drugged that you didn't form the mens rea. Now, again, the same rule applies, that if you are charged with a specific intent offence and you use it as a defence there, so you use intoxication as a defence there, then it would fall back, if it can, to another offence. So if they couldn't get you for murder, they would try and charge you with manslaughter. If they couldn't get you for Section 18, they would try and get you for Section 20. So if there is a basic intent to fall back to, the court will consider this as well. Now, however, there is a problem here. Medusa doesn't apply. And the reason Medusa doesn't apply is because you weren't reckless in getting voluntarily intoxicated, because you didn't get voluntarily intoxicated. So actually, it is a complete defence here. And the same would apply if you were charged with a basic intent offence in the first place. So if you got spiked and then you did an assault, you would be able to use this as a full defence because you weren't reckless, because you didn't choose to get intoxicated. So just another example here. So, at the beginning of the evening, your drink is spiked by drugs. You were not reckless here, as you weren't spiked. So at the end of the evening, when you do an assault or something like that, or whatever it is, it would be a full defence. So Medusa does not apply. The final case on this, I think, is a case called Hardy. And this is the one I talked about right at the beginning, where he took Valium, which would calm him down normally, but it had an adverse effect and he became very intoxicated and he set fire to a wardrobe. Bit of a strange case. And the question for the court was this voluntary or involuntary intoxication? And the answer was involuntary, as because the drug should have calmed him down and it would normally have that effect, but for some reason it didn't with him. And so therefore it was involuntary intoxication. So watch out for that one in any exam. So, where would we start if we were to write about this as sort of evaluative points or a sort of an essay? So I've got some jumping off points here for you. So each of these are not single statements you make, they're sort of points that you then try and develop. So one of the big things is obviously legal principle versus public policy. This kind of resounds throughout the entire topic of intoxication. On the one hand, legal principle, that says what the law is. The law is very clear that if you don't form the mens rea, you can't be guilty of the offence. Whereas public policy, on the other hand, is trying to protect the best interests of the public. Now, you can see a bit of both of them here. So traditionally, before Beard, the case of Beard, the law was always that intoxication was an aggravating factor, and they were very much on the side of public policy there. No, if you got drunk voluntarily, if you took drugs, it's your own fault. If you did any crime, tough luck. So that was very much in terms of protecting the public and as a deterrent almost. Beard came along, as we know, and said, well, actually, if you don't form the mens rea, that's not very fair. So they really followed the sort of legal principle there and said, well, no, if you don't form the mens rea, you can't be guilty of the offence, so it is a defence essentially. Medusa sort of challenged that because they thought, well, actually, you can't be acquitted completely of murder, for instance, or Section 18 GBH. So Medusa sort of holds the line there and says, well, actually, because you chose to take drugs or drink alcohol, whatever it is, you can't. You're not going to be fully acquitted. You can't use it as a full defence for voluntary intoxication. So that maintains a bit of public policy there, where you're still going to be convicted of something. And there's a mix of that throughout the topic, and those two key points are really, really important. Moving on to number 2, Medusa itself is actually a problem. One of the big things of law and the legal principle is that the actus reus and mens rea should coincide. They should happen at the same time. Now, we know with Medusa that that's not necessarily the case, because you could be drinking earlier in the evening and commit the crime a bit later or significantly later. And actually, the mens rea, they're saying you were reckless there, does not coincide with the actus reus that you do later of the crime. And that is actually a major flaw, in the law here, in terms of it doesn't follow standard or traditional legal principle in the fact that the mens rea and actus reus should coincide. The other problem with Medusa is, are you really being reckless when you drink or take drugs? Remember, the definition of recklessness is knowing there's a risk and deciding to take it. So knowing there's a risk you're going to commit a particular offence, but deciding to take that risk anyway. Now, that's not what is happening when you're drinking or taking drugs, particularly drinking alcohol. Most people aren't drinking a drink and thinking, well, I'm going to stab someone tonight or things like that. It might be that you might think you might do something silly tonight or stupid, things like that. But it's certainly not anticipation of doing an offence and knowing you're going to take that risk by drinking. So it really doesn't quite fit. But the reason they've done, Medusa's there is because of public policy. They don't want to fully acquit people. They don't want it to be a full defence. Otherwise, it would be pretty much free reign to get as drunk as you can and then do any offences you like. Number 3, It really does act as a deterrent, intoxication, it not being a full defence perhaps for voluntary intoxication. Is it a full deterrent if you can use it for specific intent offences? Maybe not. And you can look there at other options, criminalisation of intoxication. I mean, obviously, in theory, taking drugs is criminalised anyway, although it's possession of drugs, remember, that is the criminal aspect there. Alcohol, certainly not. I mean, there are a range of options. You could look at prohibition, like they did in America. But there are a range of arguments against criminalisation. One of the main ones, of course, being that the government make a lot of money on tax from alcohol, and it's part of the entertainment industry and social culture. There are some health benefits, particularly from red wine, if you look at the Mediterranean diet and things like that. So also in terms of like government interference in people's lives and things, it wouldn't obviously be very popular at all. So unlikely to be an option. Number 4, it's strange that there's no difference seemingly between voluntarily taking alcohol and drugs and then the impact of the defence. You would think that, taking drugs or possession of drugs is illegal, whereas alcohol isn't. So you would think that therefore there might be a difference between the two and whether you've used them or not, but that seemingly isn't. Equally, number 5, we talked about earlier about fallback offences. There is no fallback offence for theft, which is strange because that would mean if you can use it as a full defence, you were so intoxicated you didn't form the intention to permanently deprive the owner of the property. In theory, you can be acquitted of it. So it's actually essentially a full defence for theft. Number 6, the issues around Dutch courage and Gallagher, where he formed the mens rea first and then later on did the actus reus when he was so intoxicated. There is again the problem of coincidence of actus reus and mens rea there, and the fact that he formed the mens rea long before the actus reus, and essentially when he was doing the actus reus, potentially didn't even have the mens rea in his mind at that point. 7, difficulties of proof. Obviously, it's very hard to prove mens rea, hard to prove what someone was thinking, so you've got elements of difficulty there. 8, Kingston. That case looks around sort of lowering inhibitions, and should it be a defence if it sort of lowered your inhibitions and therefore you committed an offence which you normally wouldn't have because you normally would have controlled yourself, so if you were spiked, etc. So if you look at that case, it sort of makes sense there. There is an argument to be had there, but obviously because of the nature of the case, the court were obviously not that interested in arguing particularly for him. 9, Hardy, taking someone else's drugs. I mean, that was involuntary intoxication, but he had actually taken someone else's drugs. They were Valium prescribed to that person, and he knew the effects of Valium and things like that. But it does seem a bit weird that he was allowed to use that as involuntary intoxication. And 10, jurors putting themselves in the shoes of others. The idea of an alcoholic or addiction to drugs and things like that, can the jurors really put themselves in those shoes and know whether they would be so intoxicated, etc. And finally, a reform proposal from the Law Commission. They have talked about different ones. They've talked about dangerous intoxication, criminal intoxication. All of them have been rejected. If they were accepted, we would have been learning about them today. But they're interesting ones to have a look at and suggest maybe we could go towards those. They're found in Law Commission reports, so the government could accept them still and move forward with them, but obviously at this stage they haven't. So finally, how would you tackle a scenario on this? Well, obviously you want to identify the different issues in the scenario, so there's usually 2 or 3, there could be more, so you just need to look out for those. And then for each, you need to decide whether it's voluntary or involuntary intoxication, and then whether they're being charged with specific or basic intent offences. And then that table tells you essentially where you're going to start. And that is it. So you then work through and sort of decide, going through the sort of content we've been through, and decide whether they can or use the offences, talking about fallback offences if they're relevant and things like that, Medusa if it's relevant, etc. And obviously make sure you come to a conclusion. So that is it for the topic of intoxication. I hope you enjoyed that. And you found it useful, if you're enjoying these videos and finding them useful, please subscribe to this channel, because there's going to be a lot more videos, and give the video a like. The more, obviously, for that the better, and the more videos I can produce. And I hope you found it useful. Thank you very much.